So, besides sale and supply contracts, distribution contracts are widely used in the international trade practices. So it's very common to come across this type of contracts. And the contract's object here is the sale of products with the purpose of reselling them, because the distributor generally takes advantage from being the reseller of a well-known product, while the supplier has a chance to expand his sales channels and network through the distributor. So both of them take advantage, respectively, the distributor by selling a well-known product and the buyer by expanding through the distributor network his sales channels, basically. So, a distribution contract, where distribution means concessione di vendita, distribuzione. Then the parties to a distribution contract are, on one side, the supplier, venditore, fornitore, and the distributor, distributore. The object in a distribution contract is that a consideration or a price is paid in return for products purchased by distributor for resale to its customers or clients in a given territory. The territory is the geographic area where the distributor is supposed to operate and to have customers, potential clients, and customers for the seller's product. Now we have some clauses that are typical clauses that it is very, very common to come across in distribution contracts. Exclusivity is one of these clauses. Exclusivity means esclusiva, and exclusivity may be granted. To grant means concedere. It may be granted by seller to distributor in the territory, meaning that no other distributors will be appointed by supplier for the sale of certain products in the same territory, where to appoint a distributor means nominare un distributore, incaricare un distributore, and we basically may grant exclusivity to a distributor in two different ways. So exclusivity can be granted under two different settings of rules. It may be a sole distribution, where the supplier reserves its right to direct sales in the territory. So the supplier will not appoint another distributor in the territory, but he may, at his option, sell directly to the customers in the territory. He's free to do it. So he reserves the right to direct sales. And this distribution contract and this type of exclusivity is called sole distribution. So the sole distributor will be an exclusive distributor, but the seller will have reserved his rights to direct sales in the territory. The other setting of exclusivity is the exclusive distribution, where a distributor is appointed by supplier as its sole distributor of products or goods in the territory. What is the difference here? The difference here is that since the distributor is the exclusive distributor in the territory, the supplier will not be allowed to sell the products directly in the territory. Let's look at the common expression used about exclusivity. To grant exclusivity or to grant the exclusive right to do something means concedere, riconoscere un'esclusiva, un diritto in via esclusiva, riconoscere o concedere un diritto in via esclusiva rispetto a una determinata azione. In distribution contracts, we may have other typical clauses, such as minimum commitment of purchase. Minimum commitment of purchase clause refers all'obbligo minimo di acquisto da parte del distributore. Commitment is a synonym of obligation. So, we refer to an obligation under the contract on the distributor's part. Distributor undertakes to purchase minimum quantities of products in a certain period. Failure to do so may result in contract termination by supplier. So, the distributor will be under an obligation to purchase minimum quantities of products, and if he's in default, if he's in breach, there will be a big breach of contract and the supplier may be entitled to terminate the contract. You will remember that we addressed this topic before. This would be a termination by default, una risoluzione per inadempimento. So it is very common that distributors take a minimum commitment of purchase over a certain period of time. Another common clause in this type of contracts is the non-compete obligation clause. Here, there is probably an exclusivity clause. So we might have an exclusive or sole distributor who generally undertakes, so is under an obligation not to market and sell products similar and or in competition with the supplier's products. This clause is obviously a pro-seller clause because it grants protection to the seller against competitors and provides restrictions on the distributor's actions. So, the distributor will not act in any way which might be in competition with the seller's products. This non-compete obligation may also be a post-termination obligation. So sometimes in contracts we can find non-compete obligation clauses that cover the period of time after the contract is terminated. Here we have this verb to undertake an obligation, which is a synonym of to commit. The meaning is obbligarsi, vincolarsi, essere vincolato a un determinato obbligo. Now we can read these sample clauses in distribution contracts. Let's read a sample of object, appointment and exclusivity. The company hereby appoints the distributor as its exclusive distributor for the sale of the products listed in Annex 1 in the territory. During the term of this agreement, the company will neither appoint other distributors to sell nor sell directly the products in the territory. La società, con il presente contratto, incarica il distributore come suo distributore esclusivo per la vendita dei prodotti elencati nell'allegato 1 nell'ambito del territorio, which has been defined in the definitions in the contract. So a geographic area must be identified where the distributor can sell the products. So to appoint, nominare, incaricare, as his exclusive distributor. And during the term, nel periodo di durata del presente contratto, la società non darà incarichi ad altri distributori né venderà direttamente i prodotti nell'ambito del territorio. So according to this clause, the distributor has the exclusive right to sell the supplier's products in the territory. The exclusivity is enforceable even against the supplier who's not authorized to sell in the distributor's territory. So, according to what we said before, this is an exclusive distribution, not a sole distribution. The distributor will here be an exclusive distributor, not a sole distributor. Another clause, a sample, is the minimum commitment of purchase clause. The distributor undertakes to purchase from the supplier a minimum quantity of products as set out in Annex 2 within the term of this agreement. Obbligo minimo di acquisto. Commitment means obligation, as we said before. The distributor, il distributore, si impegna, si obbliga, undertakes ad acquistare dal fornitore una quantità minima di prodotti as set out, come individuata in Annex 2, nell'allegato 2, within the term of this agreement. Of course, the term of reference must be given entro il periodo di durata del presente contratto. So let's now speak about the agency contract. A company willing to expand its sales channels and network may appoint a commercial agent to find new potential clients and customers interested in a company's products. The agent is generally a self-employed intermediary, and he has been granted powers by the company to purchase and sell the products on behalf of the company. So the agent generally represents the company in the commercial transactions, and agency means both agenzia commerciale and rappresentanza. So the general condition of having powers to act in the name and on behalf of someone else. Agency, agenzia commerciale o rappresentanza. The parties to an agency contract are called respectively principal, preponente, and agent, agente. The object in an agency contract is that the principal appoints the agent either to negotiate the sale or purchase of goods or services in a given territory, or to negotiate and conclude the sale or purchase of goods or services on behalf of the principal. So to which extent can the agent act in the name and on behalf of the principal? Let's say that agency contracts objects may be of two types. We generally have a sales agency when the agent is entitled to enter into contracts with customers on behalf of the principal. So agency means rappresentanza, and to act on behalf of means agire in nome e per conto di. The agent in this case has full representation powers. He makes the deal, he stipulates the transactions, and the principal is going to be bound by the contract signed by the agent. On the other side, we may have a different type of agency agreement, and this would be called marketing agency, where the agent promotes the product but is not authorized to act on behalf of the principal, meaning that he cannot sign the contracts on his behalf. The agent here is contracting in his own name. So this is not technically considered as an agency contract, but it is very, very common in international trade practices, so it is worth mentioning.